Hey there, I'm attorney Kelly Longtin from Kelly Longtin Law, and today I want to talk to you about beneficiary and transferon-death designations and whether or not you're actually setting these up appropriately. So first of all, do you know which of your accounts have beneficiary designations? Sometimes they're called transfer-on-death or payable-on-death designations. The next question is, have you updated them recently? And another question is, are you aware of what can go wrong if there are issues with your beneficiary designation forms? Now, if you answer no to any of these questions, it may be time to review your beneficiary, transfer on death, or payable on death designations and confirm that everything is accurate, complete, and current. Now, accounts and property with beneficiary or transfer on death or payable on death designations take precedence over your will or living trust. So keeping forms updated is crucial to ensuring that your accounts and property go quickly and seamlessly to the right people. Beneficiary, TOD, and POD designations are made using legal forms that specify who will receive the asset, meaning the accounts and property and death benefits, after the original owner dies. Now, such designations allow you to pass assets directly to your beneficiaries and avoid probate. Avoiding probate can reduce estate costs, ultimately leaving more money to benefit your family and loved ones and result in faster distribution to beneficiaries. Common asset types where beneficiary designations come into play include retirement accounts such as 401k and individual retirement accounts and other retirement plans. Then you have investment accounts, so brokerage accounts and stocks and bonds and mutual funds. Then you have bank accounts, so checking accounts, savings accounts, and CDs. Then you have life insurance policies and all types of life insurance policies, including whole, term, and group. And then you have real estate or transfer on death deeds and similar alternatives, which are offered in more than half of the states when it comes to your real estate. Now, for most Americans, their home and financial accounts are the primary source of their wealth, making them central in an estate plan and making it all the more important that beneficiary designations for these assets reflect your current wishes. According to financial advisors, beneficiary form errors are among the most common and the costliest estate planning mistakes that people make. These areas usually fall into two buckets, or a few buckets. First is failure to name a beneficiary. Now, many people simply forget to complete beneficiary designation forms or put them off indefinitely. So that situation is especially common for inherited accounts. There's also outdated information. So major life events such as marriage, a divorce, or the birth of a child, or the death of a beneficiary necessitates updating beneficiary designations. There's also inaccurate or missing information. Now, mistakes in spelling, addresses, or other identifying information, or failure to provide complete information can cause delays, confusion, or even disputes when processing beneficiary designations. Now, naming a minor as beneficiary. Technically, minors can be named as beneficiaries, but they cannot legally receive or manage money and property above a certain value. If they're named as beneficiaries, a court may need to appoint a guardian to oversee the funds for them until they reach the age of majority, which is 18 in some states and 21 in others. Now, overlooking complex circumstances. A beneficiary may be unable to manage their inheritance because of a disability, special needs, poor money habits, mental health issues, or substance abuse issues as well. Now, not naming contingent beneficiaries. If the primary beneficiary dies before the account holder or cannot be located and no contingent beneficiary has been named, it will be treated as if no beneficiary had been named at all. Now, lost or invalid forms. Unfortunately, financial institutions sometimes misplace beneficiary designation forms or fail to process them correctly. Also, if a financial institution or employer changes the plan service provider or administrator, the original beneficiary designation may no longer apply, meaning that a beneficiary designation form needs to be completed under the new provider. In addition to the unintended distribution of accounts, property, or death benefits and related disputes, an invalid, missing, or outdated beneficiary designation can result in the assets requiring probate administration, possibly causing payout delays and raising estate administration costs. Also, most things that go through probate may be subject to claims from creditors, potentially reducing the amount distributed to the beneficiaries. To empathize how disastrous beneficiary form errors can be to an estate plan, there are some examples of how they could play out in the real world. First is divorce dilemma. Now, John and Mary might have been married for 20 years. Maybe John had a 401k form from his employer where Mary was listed as a sole beneficiary. They divorced and John remarried. John passed away unexpectedly, and despite his wishes for his current wife to inherit his retirement plans, the plan administrator, bound by those beneficiary designations, paid the entire sum to his ex-wife. Not all states have revocation upon divorce laws, and even in states that do, there are often exceptions and specific situations where the rules do not apply. Now let's talk about those forgotten children. Sarah had a life insurance policy from her early 20s, naming her parents as beneficiaries. She later had 2 children but never updated the policy. Upon Sarah's death, the life insurance proceeds went to her parents. And then let's just talk about probate. Robert had a brokerage account but never designated a beneficiary. When he died, the account became part of his probate estate, resulting in a lengthy and expensive legal process that delayed the distribution of his money and property to his heirs. Because the assets were tied up in probate, creditors also had easier access to those funds. Now let's talk about incapacitated beneficiaries. A woman named her adult son as her sole beneficiary on her life insurance policy. Years later, her son was in a severe car accident and became mentally incapacitated. When the woman passed, there was no clear plan for how the life insurance funds should be managed for her incapacitated son. And if he was receiving need-based benefits, those benefits could be jeopardized by his receiving those funds. A recent survey found that nearly 1/4 of Americans have not revised their estate plans since creating it. Many have also not updated it within the past 10 to 15 years. The recommended timeline for reviewing beneficiary designations is the same as for the rest of your estate plan, at least every few years or after any significant life event. During the review process, you and your attorney can dig into details, such as, are those beneficiaries still the people you want to receive your accounts? Are the beneficiaries even still living? Are they capable of managing the inheritance? Is there more than one beneficiary named? And if so, how hard is it going to be to divide the account or property? And what is the potential for conflict between those beneficiaries? Have you informed the beneficiaries that they're named? Do they know how to claim an inheritance? And are you fine with them receiving an outright distribution or are safeguards needed? When reviewing beneficiary designations, get current information directly from financial institutions to verify whom they have on record. Do not just rely on the forms you originally filled out to ensure your designations were properly processed. Even if everything looks good after a review, for added protection and control over the inheritance in complex circumstances, you may want to name a trust as the beneficiary and allow a trustee to manage the inheritance on your loved one's behalf. You can also name a charity as a beneficiary. Now, avoid letting a simple clerical error derail your estate plan. You want to schedule a review with your attorney so you can double check that you have every I dotted and every T crossed to make sure your wishes are properly going to be followed through once you pass. I want to thank you for watching. Please like and subscribe our page below, and you can follow us to learn more about estate planning and the benefits it has for your family. I'm attorney Kelly Longtin from Kelly Longtin Law. Thanks for watching.